G'day, I'm Stephen Page from Page Provan Family and Fertility Lawyers, and you're listening and watching to the Australian Family and Fertility Law podcast. In the last video, I talked about my personal fertility journey, and now I'm going to talk about my professional journey in this space. Because I get asked quite regularly, how come you ended up in this particular area? What's your expertise? Well, part of what's your interest? And part of that, of course, is, well, it's affected me personally. I've had infertility, and I've also had a child through known egg donation and surrogacy, and it was a particularly complex and difficult journey. But that's not how I started in this space. So I admitted almost 40 years ago. I feel like I'm talking to my daughter when she asked what happened during the age of dinosaurs, and I said, I remember them well, it was just yesterday. But it was almost 40 years ago when I had my first surrogacy case, and it was in 1988. And I was young and green. I'd been doing family law. I'd been admitted for a year, but I've been doing family law full time for 3 years by that stage. And this woman came into my office who'd had a child, and it had been through traditional surrogacy. So she was the genetic mother. And it was a time where Queensland had criminalised all forms of surrogacy. She wanted to keep both the child and money, and I had to tell her that she could. The contract was illegal and void, and therefore the money lay where it fell, namely with her. If the intended parents, who were a heterosexual couple, wanted to take the matter to court, there was a risk that they'd be referred for prosecution, as would she, but it's a deterrent about taking action. And even if they got there, because she was the genetic mother, she would likely succeed. And indeed, about 10 years later, there was a case, or two cases in Queensland before the one judge, where that very process occurred, not the referral, but the finding that the child lived with the traditional surrogate. So that was my first foray into surrogacy, and from time to time I would give advice in that space. But I was doing a lot of domestic violence work, and arising from that domestic violence work, I was doing same-sex domestic violence work. And one of those funny things that happens, I was invited at the last minute to speak at a seminar last thing on a Friday afternoon for a large group of lesbians about family law. Now, I hadn't had any lesbian clients at that stage, and I had no idea what I was going to talk about that was specific to lesbians with family law, because lesbians were largely excluded from family law at that stage, until I discovered that most of them had been married with a husband and often left their husband who had been violent. Anyway, the result of all of that was that I started regularly acting for lesbian clients, and I've had many of them since. And of course, while initially most of them in that era were concerned about how am I going to be excluded from my child or not showing affection to my partner, because that's what they were saying in the family court way back then. Over time, we're also talking about such things as, how do we make babies? How do we get recognised as parents? And then one thing led to another. So I was not only helping lesbians get advice about how to become parents, but then started to talk about surrogacy. And I was an early adopter of blogs. About 20 years ago, over 20 years ago, I started writing blogs. And from there, I started regularly giving advice about surrogacy. And it was really short and sharp. Queensland was the first place in the world to criminalise its residents from going overseas for commercial surrogacy. Now, it's been copied in other places since then, New South Wales, ACT, Hong Kong, and most recently, Ireland and Italy. But Queensland was the pioneer way back in 1988, the year that I had my first surrogacy case. And Queensland criminalised all forms of surrogacy. So it wasn't just commercial, it was the law. Whether it was commercial or altruistic or traditional or gestational, you name it, it was illegal. And so it was pretty simple advice. A couple would come in to see me and say, we want to have a child via surrogacy because they heard about me by some means. And next thing you know, I'd be saying, you can't do it, it's illegal. And you'd think the whole consult would be over in a minute. But then I was asked, where can we do it? Now, one of the things that I do have, of course, as a lawyer, is an obligation to my clients, a duty to my clients. And if they ask me a question like that, the expectation is that I would answer it. Now, I could have said, don't know, won't look it up. But I take my duty seriously. And in those days when the internet really wasn't available, you had to actually go to a library and look at books, I did that. And I found out where surrogacy was available. They couldn't stay in Queensland, they have to move. But interstate, for example, in New South Wales, they could do surrogacy. And then from 2004, clearly in the ACT, they could do surrogacy as legislated. So from little things, big things grow. And since then, I've advised in over 2,100 surrogacy journeys. It's just been mind-blowing. I'd never thought in my wildest dreams that this would be the niche that I would go into. But it's where I've gone. And along with doing surrogacy, I've done all the other fertility law areas: egg donation, embryo donation, sperm donation, posthumous retrieval, posthumous use, export of and import of genetic material, and advice to IVF clinics. I've advised many IVF clinics about regulatory issues. In Australia, we love regulation. For some reason, we've created 8 different versions of regulation of IVF in a country that has a population not much bigger than Shanghai or Mexico City. And our clinics operate across state borders. We've got 4 big clinics and they operate through most of Australia. So they have to traverse these borders and in the process have to deal with different laws. And it's remarkably complex. So that's the kind of work that I've done. And in the process, I've been very lucky. I have received a number of awards. They include the Queen's Ball Advocate of the Year back in 2015. The same year, I got the Rainbow Keys Award from the LGBTI Legal Service. And I wasn't a founder, but I was there very early, in fact, on the first night, and got other family lawyers engaged so that the service would take off. I was really afraid that unless there was a bit of a push, then the service would fold. And I'm delighted that the service is still thriving, growing, because greatly needed. And then in 2019, I received a teaching award for the University of New South Wales. I got roped in to be the convener and lecturer on ethics and the law in assisted reproductive technology there. 5 years I did that on top of my regular work, and then I gave it away. But in 2019, I received a teaching award. And in 2020, I received the inaugural Pride in Law Award. And in 2023, I received the Queensland Law Society President's Medal, which is that big certificate behind me. And I've got this little lapel, and the medal itself is over there. It's amazing how much stuff that you actually get for it, which was extraordinarily humbling. On the night, and I didn't seek the award, when I was told that a friend had nominated me, I was most upset because you have to work these things up, and I was really busy. But then I thought that if I didn't accept the nomination, then really what I was doing was insulting my friend who had gone out of their way to put me forward. No, I didn't know what my chances were, but anyway, I was told in advance that I was going to get the award, and on the night I discovered that there were 4, and I've since learned 5, former presidents of the Queensland Law Society who are the judging panel. That is truly a humbling moment to think that I have been seen as reaching that milestone of the most significant award that the profession can give out in Queensland. And in the process of between when I started and now, I've become a fellow of the International Academy of Family Lawyers. I've sat on a number of committees there. And on the same day that I got accepted for that, I also was accepted as a fellow of the Academy of Adoption and Assisted Reproduction Attorneys, the first international fellow outside the US and Canada. And I sit on a number of committees there. Since 2012, I've been an international representative on the American Bar Association's Family Law Section Assisted Reproductive Technology Committee. And between 2012 and 2016, I was in charge of, and with an attorney from Boston, Bruce Hale, were the main co-authors of policy by the American Bar Association as to a proposed Hague Convention on international surrogacy. It is a crying shame that there still isn't a convention, but it was an extraordinary thing that this guy with a broad Queensland accent was asked to be in charge of that project, a project that had been requested by the State Department. I have also written numerous articles, co-authored a couple of chapters, and written a couple of books. And those two books are, if I get it right with the camera, this one, When Not If, Surrogacy for Australians, and that was in 2022, and this one was in 2024, International Assisted Reproductive Technology for the American Bar Association. So I've had to look at the law around the world, and that's been much of it I knew, but because one of the fortunate things in this space, Australians go all over the world. They disperse not only to known surrogacy destinations, but many other places as well. I've had clients go to places, it's just been extraordinary. And I've had to find out about those places, and sometimes I cannot find a lawyer in the other place, and I have to do the best thing I can for my client. I have to say, look, I'm not a lawyer over there, but this is what I've been able to find out. So highly qualified advice. But that has been an extraordinary journey, and I've spoken at seminars around the world from such places as Anchorage in Alaska, Nassau and Bahamas, Los Angeles and Chicago, right throughout Australia. I haven't yet spoken in person in the Northern Territory, although I delivered a seminar for Northern Territory practitioners about its Surrogacy Act after it got enacted in 2022, because I was on the Northern Territory Government's Surrogacy Working Group. And I've been roped in or made submissions to various government inquiries about IVF regulation, surrogacy and related topics from 2012 onwards. And there is a broad list. And I think I forgot to mention, I don't know how I forgot this, but I am also Secretary of the Fertility Society of Australia and New Zealand. I am the only lawyer on the board, and I'm the only lawyer who has ever been on the board. And I was originally appointed to the board, but I've since been elected by members to the board. But of the various changes that I've advocated for over the years, there are a couple that stand out. And I took great pleasure, a lot of work, being on the Northern Territory's government surrogacy working group to ensure that the Northern Territory, which was the last to legislate surrogacy, got it right. But the two big changes that I have, or several big changes that I have sought, are that if you're intended parents, you shouldn't be told where you have to do IVF. We've had restrictions in the past in various states telling intended parents, we won't recognise your parentage. You can't get a parentage order here unless you do the IVF here. And we've seen that in the ACT, and we've seen that in South Australia and in Western Australia and in Victoria. Now, I have advocated over the years to get rid of that, and I'm delighted that's gone in South Australia and the ACT, and it's now been legislated to be gone in Western Australia. Sadly, it's still in place in Victoria, because Victorians should be entitled, if they want to go to a clinic somewhere outside Victoria, for example, if they've got a sister-in-law who is a donor or a surrogate interstate, to go to a clinic there rather than a clinic in Melbourne. The second is to enable surrogates to be recognised that they have bodily autonomy over their bodies and the birthing process. Queensland legislated that in 2010. I had nothing to do with that, but when I read it, I thought, this is brilliant. It reflected the common law, but there it was in black and white in statute. And from that time on, I've always had it in my written surrogacy arrangements, even for every state where it hasn't been part of the statute law, because I had a surrogate in 2010 who thought that was brilliant, that it actually said in black and white in the document that they were signing that this is what they've agreed. And she found that really empowering. And so that's what we've done. And since then, the law has changed. Again, advocacy from me, amongst others, in Victoria. Tasmania was already put it in its bill, but I supported it, but also in the ACT and also in South Australia and also in the Northern Territory bill and also in the recent changes in WA. The holdout now is New South Wales. I hope that happens in New South Wales. And the third thing that I've always wanted to emphasise is that if you're talking about surrogacy in particular, you've got to talk about human rights. And a lot of the discourse about surrogacy is the human rights of the surrogate. And don't get me wrong, I want to support the human rights of the surrogate. I've acted for many surrogates over the years, and as I said in my own journey, had a surrogate. I want to make sure that surrogates' human rights are upheld. But the most vulnerable person in the whole surrogacy journey is the child. And in my view, the child's human rights must come first, must be the paramount concern. And that there's a lot of lack of discussion about that, sadly, about how to recognise the child's parentage. Often the argument is put, well, it's the surrogate's child. Well, that's not how surrogates see it, and that's not what the research shows. Surrogates typically see the surrogate, the child, being the child of the intended parents. And we have done a poor job in this country about quickly recognising the parents of the intended parents, leaving the child's parentage vulnerable. So that is something that I've wanted to emphasise. And it's also, if you look at who else is there, the surrogate often has a partner. And in some of the laws, the partner is ignored. So here is this pillar to help support the surrogate. Without the surrogate's partner's support, this surrogacy journey would never happen. And if you have a non-supportive partner, then watch out, it'll be a ride to hell and back. But also, the surrogate's partner is often recognised as a parent. So why shouldn't they be recognised in statute and be part of the counselling process, etc.? So I've certainly emphasised that. And the other issue is, of course, the human rights of the intended parents. The discourse is often that the intended parents are abusive, not usually. And I've seen, sadly, cases where everyone, these are overseas cases primarily, but overseas cases, I should say, where everyone but the doctor or the agency has been the subject of some kind of abuse. For example, the surrogate's partner, the egg donor, the intended parents, and the child. So one thing that I've tried to emphasise at every stage is that human rights are important. I do it in my submissions to court. I do it in my submissions to government. And at least on one occasion, I've been very happy about how that gets raised in legislation. Because in 2018, the then South Australian Attorney General, Vicky Chapman, sent through to me and many others, the stakeholders, a draft surrogacy bill. And I suggested a couple of changes to that bill, one being that South Australians not be restricted to doing IVF in South Australia, except Another being that that one of the principles of the Act is that the human rights of all who are affected by the surrogacy journey must be respected. And that's now part of the Surrogacy Act 2019 in South Australia. So it's good to be balanced, and I'm lucky to be able to do this work. Nothing gives me more pleasure than helping people have children who aren't. And to give an example, just the other day, I had a woman say to me that she'd been born without a uterus because she had MRKH syndrome. And at the time that was said, she knew that her only way of having a child is via surrogacy. In theory, you can do adoption, but in reality, there are no children available to adopt in Australia. So few and far between. And I said to her, many of my clients don't have uteruses. All my male clients don't. Which she's had a bit of a smile. And then I said, my first client who had MRKH syndrome was back in 2010, and I've had many since. So I wanted her to hear loud and clear that she wasn't alone, that I was very empathic to her needs, and as with all my clients, undertaking fertility work, that it is a great honour to help, because no one would want to talk to a lawyer about making a baby unless their partner was a lawyer or they had to. Thank you for watching and listening to the Australian Family and Fertility Law podcast. I'm Stephen Page from Page Provan Family and Fertility Lawyers.